5 seconds to go. Start. At the outset, the learned counsels for the respondents raising preliminary objection had submitted that the appellant, having failed to mention about the SLP criminal number 9384 of 2023, which was preferred by the appellant against the co-accused for cancellation of the bail arising out of the same FIR, the present appeal was liable to be dismissed under Order 22 Rule 23 of the Supreme Court Rules 2013. The said submission cannot be accepted. Rule 22 of Order 22 mandates inter alia that no petition shall be entertained by the registry unless it contains a statement as to whether the petitioner had filed any petition for special leave to appeal against the impugned judgment or order earlier, and if so, with what result. Rule 23 thereof states that the court shall, if it finds that the petitioner has not disclosed the fact of filing a similar petition earlier and its dismissal by the court, dismiss the second petition if it is pending. It may be noted that earlier no special leave to appeal has been filed against the impugned judgment and order dated 19th October 2023 passed by the High Court, and hence question of filing second petition does not arise. Though the SLP criminal number 9384 of 2023 was filed earlier by the appellant seeking cancellation of bail granted to the co-accused in respect of the same FIR, the same has already been referred to in the impugned order by the High Court. This set of appeals cannot be treated as second petition as sought to be canvassed by the learned counsels for the respondents. So far as the merits of the appeals are concerned, the learned advocate Mr. Rajat Nair for the appellant has vehemently submitted that the High Court had miserably failed to comprehend the correct import of Section 18 read with the definition of Terrorist Act contemplated under Section 15 of the UPA for releasing the respondents on bail who have been charged with very serious offences. According to him, the High Court had fallen into patent and manifest error in not appreciating the overt acts and commission of alleged offences by the respondents as stated by the listed witnesses, protected witnesses. Mr. Nair, placing heavy reliance on the statements of the protected witnesses, listed witnesses, had taken the court to the said statements to show the role and involvement of each of the respondents in the commission of the alleged offences under the IPC and UAPA. According to him, though some of the witnesses whose statements were recorded under Section 161, 164 CRPC and relied upon by the appellant were the members of the PFI when it was not banned by the Government of India, they had not participated in the alleged unlawful activities, and hence their statements till they are rebutted or contradicted could be relied upon. He further submitted that the High Court has committed grave error in trivializing the serious allegations made against the respondents by holding that except the witnesses having stated about respondents organizing weapon training for using knives and swords and to train members to throw beer bottles filled with water on targets, there is no material to suggest commission of any offence which falls under Section 15 of UPA, whereas all these alleged acts were part of the preparation of committing terrorist acts, particularly when the respondents were imparting training as to how to hurl bombs by using water filled beer bottles and how to use weapons like knives and swords to strike terror in the mind of people. Stop.